Good afternoon, sir. Can you continue to see and hear me?
Yes, thank you.
Thank you very much. Good afternoon, Mr. Atkinson. Can we turn to the third subtopic of the fifth topic? The fifth topic was reasonable lines of inquiry, and the third subtopic was horizon and obtaining from Fujitsu data, in particular ARQ data. And you address this on page 221 of your report, at paragraph 628.
Yes.
If we scroll down to 628, thank you. And you say, where a suspect described issues with the Horizon system, unexplained losses, recurrent error notices, or simply asserted they could not explain what had happened when confronted with a Horizon record of a shortfall, then a reasonable line of inquiry is to identify what the root cause of that shortfall is. That involved firstly obtaining underlying data and its assessment for bugs, errors, or issues. You say that the failure to undertake such inquiries was almost routinely identified by the Court of Appeal in Hamilton as a serious investigative deficiency. In those and many other cases, there was no inquiry for bugs, errors, and the ARQ data was not obtained. And I think earlier in your report, you say that in some cases, the failure to pursue this reasonable line of inquiry was picked up by a prosecution lawyer, but the prosecution lawyer did not wait for the outcome of the investigative steps before positively finding or advising that a prosecution should be pursued. Is that right?
Yes.
That was paragraph 230 of your report. Can I seek to exemplify some of those conclusions in relation to specific case studies? And this will take a while, but I'm going to devote some time to it because of the importance potentially of the issue. In paragraphs 37 to 50 of your report, I think that starts at page 21. We scroll down, thank you, 37 onwards. You're addressing here the investigation and charging decision in relation to Lisa Brennan.
Yes.
And if we go forwards to 43 and 44, that's paragraphs 43 and 44, on page 23. You say that there was some engagement by the reviewing lawyer with the identification and pursuit of reasonable lines of inquiry.
Yes.
Yes? And you cross-refer us in footnote 30 to poll 304-7331. And then you tell us over the page at page 24, in paragraphs 45 and 46, that the investigator, and it's Mr. Bradshaw again, responded to what the reviewing lawyer had said 2 weeks later, indicating that further investigations had been conducted. But that you conclude in 46 that there was no evidence that any inquiries were made as to whether the Horizon system on which the case depended was operating correctly.
Yes.
Can we just look, please, then, at the two documents that found those conclusions? To start with, poll 304-7331. I think this is the memorandum that you were referring to.
Yes.
And if we just scroll down a little bit further, we can see what Miss Berridge, a senior lawyer in the Criminal Law Division, was advising. I would like to know, and then 1 to 10, I think it's right, isn't it, that none of those lines of inquiry identified by the reviewing lawyer express addressly reviewing Horizon data or obtaining ARQ data?
No, that's right.
identifying the potential for any bugs, errors, or defects in the Horizon system,
No.
nor contacting Fujitsu with regard to the integrity of Horizon data.
No.
And then if we can look to the response, poll 304 7335. And Mr. Bradshaw's reply, as you say, about a fortnight later, your memo, Teresa Berridge refers, and then a series of responses to the questions that she asked, all numbered paragraph 1, but I think we can see if we compare them side by side that they are responses to her paragraphs. None of those lines of inquiry involved the reviewing of Horizon data, including ARQ data.
No.
The identification of bugs, errors, or defects in the Horizon system, nor contact with Fujitsu in relation to the integrity of Horizon data.
Yes, and the second paragraph down in relation to error notices was perhaps as near as it got to considering whether there had been issues with the system that had been flagged up, but that's not the same thing as what you've just been asking me.
No. And was there any evidence in Lisa Brennan's case that Fujitsu were contacted for information or provision of data that you saw?
No.
And I don't think any witnesses from Fujitsu were ever called in Ms. Brennan's trial, is that right? Can we move on then to your report? So back to the main report, please, at page 30. And paragraphs 63 to 69. I'll just wait for the system to catch up. Page 30. You're here dealing with David Yates's case, yes?
Yes.
And you note in paragraph 69, which is on page 32, if we scroll down. Thank you. There's no evidence or that any checks were made on the Horizon system for evidence or faults or other errors that might have impinged on the records that Mr. Yates described in his interview or otherwise.
No, that's right. And that was a case where Mr. Yates was describing errors appearing on what he was doing that he couldn't understand.
The Court of Appeal concluded that there was nothing to indicate that any ARQ data was obtained at the time of the criminal proceedings in Mr. Yates's case.
Yeah, that's right.
That's Hamilton at paragraphs 330 and 331. Was that observation or finding one that accorded with your review of the papers?
Yes.
And again, was there any evidence that you saw that Fujitsu was ever contacted for the provision of data or information in relation to Mr. Yates's case?
No.
And I think was there any evidence that any witness statements from Fujitsu employees were ever prepared or provided to the post office prior to Mr. Yates's guilty plea?
No.
Thank you. Can we move on to David Blakey's case, please? And that's relevantly paragraph 87 onwards in page 38 of your report. And you address the investigation between paragraphs 87 and 94. And if we go to paragraph 94, which is on page 40, at the foot of the page, you say, despite Mr. Blakey's account of issues with its operation, that's Horizon's operation, there were no inquiries made of Horizon data or the operation of the Horizon system to see if this could explain the issues that Mr. Blakey described, this significant limitation to investigation was well identified by the Court of Appeal, and you set out a citation from the Court of Appeal's judgment in Hamilton at paragraph 351.
Yes.
So again, was there any evidence that Fujitsu was ever even contacted for information, for assistance or anything else in relation to Mr. Blakey's case?
No, and in his case, he did identify that there were discrepancies arising in the system that he couldn't explain. He was clear that he was not responsible for them. He was clear that his staff were not responsible for them. He couldn't explain how they had happened. He was told by the investigator that what he was saying sounded ridiculous, and no check was made to understand what it was he was saying to the extent he was able to describe it.
I think this is a case in which there is no evidence that any witness statements from Fujitsu employees were ever prepared or provided to Mr. Blakey as part of the investigation.
No, not that I've seen, no.
Can we look, please, because this is a case in which Jarnell Singh advised, at poll 304 4820. Can we see that this is a memorandum in the case of the prosecution of Mr. Blakey? If we go to the second page, please, and just scroll down, we'll see that it's signed off by Jarnell Singh.
Yes.
And if we go back to page 1, please, and if we just scroll down so we can see the body of the text, thank you. Mr. Singh says, in my opinion, there's sufficient evidence to afford a realistic prospect of conviction of Mr. Blakey for an offence of theft with a low prospect of success, and for false accounting with a high prospect of success. We've addressed that issue this morning. Is that kind of sentence that we see there, the bold statement of the sufficiency of evidence, one that you saw in many charging memos?
They usually stopped after identifying the offence. The low prospect of success part is something that was less common.
So a bold statement, in my opinion, there's sufficient evidence to afford a realistic prospect of conviction.
Yes.
Full stop.
Yes. And it's of note, in just taking this as an example, that the lawyer here identified that a reasonable line of inquiry would be to rule out that others working in the branch had been responsible, and so he asked for statements to be taken from them. He didn't go on to consider whether statements needed to be taken to deal with whether it could have been a computer error rather than the responsibility of Mr. Blakey.
And so in this case, would you agree that Mr. Singh did not advise, or failed to advise, as to reviewing of Horizon data, including ARQ data?
Yes.
And that he ought to have done?
Yes.
Identifying the potential for any bugs, errors or defects in the Horizon system, and that he ought to have done?
Yes, and even if Mr. Singh didn't understand ARQ data or what it was, one would have looked to see, as a reasonable line of inquiry, that checks ought to be made to understand that the material that was being relied on, namely the Horizon records, was reliable, given that the defendant in his interview was raising issues with the operation of the system.
And so even though he, Mr. Singh, might not have broken it down as I have, a question to Fujitsu, can you assure us as to the operation of the integrity of the system?
Yes.
Can you supply us with ARQ data? Can you identify whether there are any errors, bugs or defects that might impinge on the reliability of the data? You would expect, am I understanding this correctly, some general statement of request that was focused on the reliability of the material that
Yes.
the prosecution was relying on?
Yes. and how detailed it was would depend on how much he knew. And you might then expect to see a discussion between investigator and lawyer as to what needed to be done about that, and that would be an entirely appropriate dialogue to have.
Did you see any of that healthy dialogue between lawyer and investigator on horizon reliability in any of the cases?
No.
Can we turn, please, to page 46 of your report? Between paragraphs 109 and 115 of your report, you address the investigation of Tahir Mahmud.
Yes.
And in paragraph 114, which is on page 48, you note that there is no evidence or awareness of issues with Horizon in the investigation.
No. The only place that questions of any errors in Horizon arose was in the interviews with Mr. Mahmud, where he described as best he could the problems that he was encountering and what they had led to.
The Court of Appeal observed in Hamilton, it was paragraph 322 of the court's judgment, that there is nothing to indicate that any ARQ data was obtained at the time of the criminal proceedings in Mr. Mahmud's case. Did that accord with your examination of the materials?
Yes.
Was there any evidence that Fujitsu was contacted for information or assistance in relation to Mr. Mahmud's case?
No.
And was there any evidence that any witness statements from Fujitsu employees were deployed in Mr. Mahmud's case?
No.
Can we look at how the reviewing lawyer approached it? Poll 305 2884. We can see if we go to the second page, if we scroll down, sorry, third page. This is signed by Juliet McFarlane, a principal lawyer in the Criminal Law Division.
Yes.
Go back to the first page, I think we'll see it's dated the 27th of May 2005. We can see how she advises, in my opinion, the evidence is sufficient to afford a realistic prospect of conviction of the above named on the charges set out on the attack schedule. Is that the more common formulation?
Yes.
And I think without reading this in detail, would you agree that Ms. McFarlane did not advise as to any reasonable lines of inquiry that required to be pursued relating to reviewing ARQ data or any other Horizon data?
No.
Identifying the potential for any errors, bugs or defects in the system, or contacting Fujitsu in relation to the reliability or integrity of Horizon data upon which reliance was to be placed?
She took account of the fact that the error notices that had been obtained didn't accord with this all being the result of a mistake. She then went on to consider that theft was not to be pursued because there were other candidates who could have carried out the theft, and to rely instead on false accounting on the basis of a covering up of losses in the records, whether they'd been caused by Mr. Mahmud or not, without having actually carried out or advising that there should be carried out any checks either as to where the money had gone or as to what had happened on the computer.
And was that adequate or not adequate?
No, it wasn't adequate.
Thank you. Can we turn to the case of Carl Page, please? That's page 59 of your report. between paragraphs 149 and 152 of your report, you look at horizon issues in relation to the prosecution of Mr. Page, and you note that in the course of the retrial, a defence expert report from Timothy Taylor of KPMG was served on behalf of the defence, which raised the prospect that the £282,000 deficiency, quote, could in practice be the result of unidentified errors or differences in Horizon, and that the prosecution case depended on Horizon working correctly throughout the indictment period. Yes?
Yes.
In the light of that defence expert report, suggesting that the £282,000 could in practice be the result of unidentified errors or deficiencies in Horizon, was there any evidence that the Post Office sought to investigate the existence of any such unidentified errors or deficiencies?
No. And the taking on board all the need to be careful about material generated after the event, the second site review didn't point to any which accorded with the lack of any evidence of a contemporaneous material in that regard.
The Court of Appeal observed, it's paragraph 284 of the Court of Appeal's judgment, that there is nothing in the Post Office case papers to indicate that any ARQ data was obtained at the time of the criminal proceedings in Mr. Page's case, whether at the initial trial or upon retrial. Did that observation accord with your examination of the case papers?
Yes.
Can we turn, please, to paragraph 223 onwards in your report? That's page 85. Where you're addressing the investigation in relation to Suzanne Palmer. This is paragraph 223 to 227. In relation to that case, Miss Palmer's case, did you see any evidence that Fujitsu was ever contacted for information or evidence in relation to Miss Palmer's case?
No.
Was there any evidence that any witness statements from Fujitsu employees were ever served on Miss Palmer?
No. And
therefore none called at trial? Can we look, please, at what the reviewing lawyer advised at poll 305 2990? Tenth of March 2006, in the case of Suzanne Leslie Palmer. If we go to the second page, please, we'll see that this is one of Mr. Jarnail Singh's charging advices.
Yes.
And then back to page 1. I'm of the opinion there's sufficient evidence to afford a realistic prospect of conviction of Miss Palmer for the offences of false accounting. And then, if you look at the remainder of the page, and then over the page, is it right that Mr. Singh did not advise when he ought to as to any further reasonable lines of inquiry, including reviewing Horizon data?
Yes.
Identifying the potential for bugs, errors or defects in the Horizon system?
Yes.
And lastly, contact with Fujitsu regarding Horizon integrity?
Yes. I mean, on the contrary, he said that there was nothing further that needed to be done.
We can see that if we go back a page, please. If we scroll down. The line, no further statements need to be obtained at this stage.
Yes.
But then, conditionally, if there's an election for trial or refusal of jurisdiction, or if a not guilty plea is entered, then the following statements are necessary, but none of those address the 3 points that I've asked you about.
No, and the statements that are listed there are all tidying up the evidence for presentation to a jury. I don't read number 4 that any other statements the officer considers relevant to be identifying to an investigator that they needed to go and obtain ARQ data.
Page 114, please. Sorry, my mistake. Yes, page 114 of your report, please. Page 114. You're dealing here with the investigation between paragraphs 312 and 320 of the investigation concerning Mr. Peter Holmes.
Yes.
In paragraph 316, please, which is on page 116. You're addressing in 316 the interview, and you summarise what happened in the course of the interview.
Yes.
He asserted, second line, that shortages could be an issue with Horizon or malfunctioning equipment. And then fourth line, believed that the shortfall on each occasion was something that the computer had done or failed to do.
Yes.
Seventh line, he raised specifically issues with the Horizon system for 3 months, about 9 months previously.
Yes.
10th line, he denied emphatically stealing the money.
Yes.
I think we can see if we look at poll 305 2178. We can see his defence statement, name of accused Peter Holmes, his solicitors and the date of it. And then if we scroll down to what his defence statement said, second sentence, I believe that either the Horizon system has on occasion been at fault and ultimately created the shortfall by creating incorrect entries. Would you agree that both in interview and in his defence statement, Mr. Holmes was squarely raising the operation of the Horizon system as being responsible for the shortfalls?
Absolutely.
Is there any evidence that Fujitsu was ever contacted for information or evidence in relation to Mr. Holmes's case?
It's not absolutely clear. There was a degree of Horizon material that the investigation did obtain, transaction logs, for example, although it wasn't clear where those had come from, and they may have come from the branch rather than from anywhere else. And the investigators' report, there were 2 versions of it in this case, and the updated version made reference to faulty equipment and asserted that this has been checked and the allegations are unfounded. It wasn't clear from the report how they'd been checked or with whom. So I can't say positively that nothing was done in terms of contacting Fujitsu. What I can say is I didn't see any evidence of the results of any such contact or indeed any document that set out such contact.
Let's look at this in more detail then, because you're rightly pointing out that there is some mention of the possible pursuit of an inquiry as a result of something mentioned in interview or
Yes.
defence statement. Can we see how that came about? And can we start, please, with whether it was the reviewing lawyer that caused this inquiry to be made? Poll 304 6488. 3rd of October, that's the wrong document. That's Miss Rudkins.
Yes.
There's obviously a ghost in the machine at my end here. I'll skip that and come back in a moment if I can. If we go to your report at page 117.
The document might be poll 000050912. That's the reference I give in the report for the charging decision, but I was grappling with a lot of poll references.
Thank you. Poll 000050912. Thank you. This is the memorandum in the case of Mr. Holmes, dated the 16th of February 2009. And if we look over the page, please, and scroll down, and page 3. Oh, no. It's a Juliet McFarlane case.
Yes.
If we go back to the beginning, please. She advises, in my opinion, the evidence is sufficient to afford a realistic prospect of conviction on the charges set out in the schedule. There's a medium prospect of success. I suppose the second paragraph might be a nod to the public interest test, might it?
Yes. Though not an analysis of it.
Yeah. So it doesn't mention the words public interest,
No.
nor does it explain how that position has been arrived at.
No.
No further statements need to be attained at this stage in the 6th paragraph. And then, if we scroll down, if those conditions are met, the following statements should be obtained. And then over the page. Is there anything in there that suggests that the reviewing lawyer advised as to a reasonable line of inquiry relating to the operation of the Horizon system?
No.
Can we go back to your report, please, and look at the case of Lynette Hutchins? And that is page 152. At paragraph 423 at the foot of page 152, you tell us that John L. Singh advised it was likely that the defence would assert that Horizon was not working and therefore, quote, it would be more prudent for the officer to complete his inquiries and further investigations and produce the evidence listed in the advice, including evidence rebutting the allegations and criticisms made in the pre-prepared statement and, quote, statements dealing with the integrity of the Horizon and call logs to the Horizon support desks. And you say it's of note that the identified approach was to rebut the assertions, not to investigate whether or not those assertions might be true.
Yeah.
Are you focusing on the formulation of the request,
Yes.
the phraseology used?
Yes.
What did you take from that?
Well, in terms of identifying a reasonable line of inquiry, that's a line of inquiry that leads to or from, that implicates or exculpates. And this was effectively saying the defendant said that he was encountering problems on the system. We need to disprove that. And that's not it. I'm not saying that it was wrong to say we need to pursue that, because clearly they did need to that was a reasonable line of inquiry to pursue, but I found the way it was put perhaps less than helpful.
In paragraph 425 of your report, further down the page, please, you tell us that on the 4th of January 2012, Martin Smith of Cartwright King produced a charging advice recommending that Miss Hutchins be charged.
Yes.
If we can look at that, please, poll 305-7341. And if we go to the last page, please. We can see this is produced by Martin Smith of Cartwright King on the 4th of January 2012. And then back to the beginning. If we just scroll through and look at what Mr. Smith says, the audit in his first paragraph, very strong evidence to support the allegation that Mrs. Hutchins had inflated the amount of cash held in the branch, usually by inflating the figure for cash held in £50 notes. Third paragraph, if you scroll down. In interview, a prepared statement was read out. She admitted to altering the cash declarations and suggested she had done so only since the migration to Horizon Online. Over the page, furthermore, she said at the time of migration all accounts balanced, which was clearly untrue. She also gave problems which she alleged she'd experienced with the Horizon system. Whilst Mrs. Hutchinson has denied stealing money, she has not put forward any explanation as to how the deficit has arisen. And then further down, defence case. It's not known whether she will admit or deny wrongdoing. However, given the evidence and the admissions, it's difficult to see how she could successfully argue her actions had not been dishonest and she'd not had the intention to make a gain. I've seen the memorandum of the 17th of June 2011. That's the one in which Mr. Singh has advised Horizon-related integrity issues should be pursued.
Yes.
And he says, I've seen numerous statements have been taken, no further statements need to be taken at the present time, and that she should be charged in the last paragraph on the page.
Yes.
Would you agree that the statements which Mr. Singh had recommended be obtained were not in fact obtained, going to the Horizon integrity issue?
Not that I saw.
Mr. Smith in this memorandum dismisses Miss Hutchins' allegations concerning the Horizon system, which he says they do not appear to be of any relevance.
Yes.
Is that a view with which you agreed or disagreed?
Disagreed.
By reference to the fact that the lines of inquiry that Mr. Singh had recommended be pursued and what is said in this charging memorandum, was it appropriate or inappropriate for a charging decision to be taken in Miss Hutchins' case without the Post Office having at that stage obtained statements, quote, dealing with the integrity of Horizon?
Well, one of the things that she had said in her prepared statement was that she had not been responsible for the loss, that the loss had arisen on the system, and that what she had been doing was to adjust the figures in the hope that it would balance out in itself in due course, that the system that had created a problem would sort the problem out. And that clearly was relevant to the assessment of her honesty or otherwise, which was dismissed by Mr. Smith in his advice. And so just testing that alone required an understanding of whether these were irregularities as a result of the system and the way it was operating or not. But beyond that, there was the wider need to test the reliability of the evidence being relied on, rather than to proceed from the basis, as Mr. Smith did, that it was reliable without more.
Thank you. Can we turn to Joan Bailey's case, please? This is page 159 of your report. (159). And between, if we scroll down, paragraphs 444 and 452, you address the investigation that was undertaken in the case of Joan Bailey.
Yes.
Was there any evidence that Fujitsu was contacted for information or assistance in relation to Joan Bailey's case?
No.
And were there any witness statements obtained from Fujitsu served on Mrs. Bailey before she accepted a caution?
No. And it's right to say in her case, she, in interview, did raise the question of and her belief that there were problems in the Horizon system that were giving rise to issues. The investigator, Mr. Bradshaw again, in her first interview, reassured her that the Horizon system did not have glitches, and in her second interview told her that any issues with Horizon were down to carelessness or incompetence by the operator, and then carried out no investigations that I could identify to test whether what she was doing her best to describe might be an error in the system.
Thank you. Can we move on to page 170 of your report, please? And from paragraphs 483. In fact, it's over the page. Thank you. 483 to 488 of your report, you address the investigation undertaken in Miss Allison Henderson's case.
Yes.
The Court of Appeal observed in the Hamilton Appeals, their paragraph 158, that there was nothing to suggest that any ARQ data was obtained in Miss Henderson's case. Did that observation accord with your examination of the case papers?
Yes. I mean, it's right to note that this was one of the cases where I didn't have a report from the investigator. But on what I did have, I didn't see anything that ran contrary to the finding the Court of Appeal had reached.
Was there any evidence that you saw that Fujitsu was contacted for information or evidence in relation to Miss Henderson's case?
No.
Can we look, please, at the reviewing lawyer's advice, poll 304-7159? Uh, 21st of May 2010, Allison Henderson. If we go over the page, please, and scroll down. we can see that it's the head of criminal law, Mr. Wilson's advice memo.
Yes.
Back to page 1, please. We can see the formulation that he uses. In my opinion, the evidence is sufficient to afford a realistic prospect of the above named on a charge of theft as set out on the attached schedule. I've not drafted a commencement date in theft, as I'm not clear when we're saying the losses started. Can you fill in such a date and explain to me your rationale for relying on this particular date? Doesn't seem appropriate to consider false accounting charges. It would be helpful if we could obtain some evidence to refute the possibility that the money she alleges must have gone missing was not, in fact, the account during the last accounting period prior to the audit. Do you understand what that means?
Not altogether, no.
In any event, in this advice, and we can scroll down the rest of the page and look over the page too. If we scroll down. Do you agree that Mr. Wilson did not advise as to a line of inquiry existing concerning the review of Horizon data, including ARQ data?
No, that's right.
The potential for bugs, errors or defects in Horizon to be investigated, or indeed any contact with Fujitsu in relation to the integrity of Horizon data?
I have a vague memory that there was a suggestion at one stage in Ms. Henderson's case that they might, if the matter went to trial, need to get a statement from Mr. Jenkins, who they had started to get statements from by then, but it never got that far. But certainly in the time that this was being investigated, I didn't see any issue with any steps being taken to get such ARQ data, for example, or contacting Fujitsu more generally.
If we look at page 172 of your report, um, 172. You address the interview in paragraph 484. In 485, you say the interview was combative and was indicative of a disciplinary approach as opposed to an investigative approach. Just whilst we're on that, taking it out of turn, what do you mean by it was indicative of a disciplinary approach?
It read as if this was a case of proven misconduct that Miss Henderson was being asked to justify rather than an investigation with her of how it was that losses identified by Horizon might have arisen. And certainly she felt it to be that because she said so, that she felt that the investigators had drawn their own conclusions before they'd spoken to her.
You tell us in 486 that bank statements were obtained. Can you recall what the reason was for the obtaining of bank statements in this case as opposed to others?
That, I think, was to see whether there was any evidence of that the money had gone to her, and there wasn't.
You say in the third line, it's not clear whether there were inquiries as to calls to Horizon Help, the Horizon Help Desk or the MBSC, as would be a standard line of inquiry in these cases. By that, do you mean as should be a standard line?
Yes, yes.
There was no evidence of awareness of Horizon issues in the course of the investigation, and there does not appear to be any checks on the accuracy of Horizon information relied on,
No.
or checks as to whether there had been any faults.
No, and the Court of Appeal observed that they couldn't see any suggestion that ARQ data had been obtained.
Thank you. Can we move on, please, to the case of Khayyam Ishaq, which is page 211 of your report. If we scroll down to disclosure, turning to a slightly different issue here, which is where there has been some investigation. We've looked at a slew of cases now where there has not. I want to look at some cases where there has been an investigation of sorts.
Yes.
Between paragraph 602 and 606, you tell us about the approach that was taken by a lawyer at Cartwright King called Rachel Panter.
Yes.
To disclosure in the case. And is this a fair summary that she advised it was sufficient for Mr. Jenkins to address Horizon integrity issues on a generic basis because the sub-postmaster had not raised a specific issue with the Horizon system itself? They've all been generic to date.
Yes.
If we look at that underlying document, please, poll 0005 9402. And if we go to the last page in this chain, please, we can see this email is signed off. If we scroll up, please, by Rachel Panter. If we scroll up, keep going, keep going. There, it's an email to Mr. Jenkins of November the 16th, 2012. And she says, as you may already be aware, your expert report detailing the reliability of the Horizon system has been served as evidence in a number of post office cases that are at various stages of the court process, most of which are listed for trial in the early part of next year. It should be noted that to date, most if not all cases raising the Horizon system as an issue have been unable, stroke not willing, to particularize, what's easy for me to say, what specific issues that they have with the system and how that shapes the nature of their defence. As we already have your detailed report, I'd like to survey it in each case listed below. All of the following cases have raised issues with the reliability of the Horizon system, and then Khayyam Ishaq's is listed. I would like to serve your report in the remaining cases and have attached a case summary of each case listed above so that you may familiarise yourself with the facts of each case. I stress I do not anticipate that all of the above cases will reach trial. Could you read the case summaries attached and send 5 original signed and dated copies of your report to me as soon as possible? And then some other material. Can we go back to your report, please, at page 213? Page 213. You tell us at page 600, paragraph 605, that Mr. Jenkins replied asking if his existing report from Patel could not be used, raising the question of whether contact with him should be by the post office rather than their solicitors. And Miss Panter commented to a colleague at Cartwright King, I can clarify with Gareth, it doesn't matter that specific cases are not quoted in his report, as not one of them has raised a specific issue with the Horizon system itself. They've all been generic to date. And then you offer your view in paragraph 606 as to this.
Yes.
You say, as an approach to disclosure, the obvious difficulty with it is that it makes disclosure dependent on a defendant understanding what's gone wrong, what issue with the Horizon system had led to accounting imbalances, when a reason for the defendant seeking to cover unexplained losses was that they did not understand why they were happening. Can you explain what you mean there, please?
So the approach that Miss Panter adopted was that it wasn't necessary for Mr. Jenkins to address the data in relation to a particular case, such as that of Mr. Ishak, because defendants such as Mr. Ishak had not spelt out what it was that had caused the problem on Horizon in their case, why the losses had been shown on the system in their case. But that, of course, required the defendant to understand why the errors had arisen in their case. And certainly by this point, at the end of 2012, it had been repeatedly clear from repeated suspects that they didn't understand what the problem was. They just knew there was a problem, and they described what they had encountered in their interview, as Mr. Ishak did here. And so rather than testing the reliability of the evidence that the case was founded on, and where they had someone who could do that testing for them in the shape of Mr. Jenkins, asking Mr. Jenkins to test it, to understand whether the system had been working properly in this branch at this time. Instead, because the postmaster couldn't give chapter and verse as to what was causing the problem, it was deemed sufficient to have a generic report that simply asserted that the system was all right.
You make that point that you've just made there in the last two sentences of paragraph 606. As his approach in the case of Gareth Allen shows, it was possible for Mr. Jenkins to access Horizon data for a particular post office to see whether there were any issues. But the approach identified by Miss Panter did not facilitate such an approach. And yet it was that approach that was required. Would you agree that in addition to having the effect of restricting the analysis which Mr. Jenkins might undertake, the effect of the approach that Miss Panter adopted to disclosure was that in many of the cases that you've reviewed, including this one, Fujitsu were never asked to analyse the transaction data at all?
That's right. And the case of Mr. Allen that I referred to there was a case where Mr. Jenkins has said that it was possible to look at the ARQ data in relation to Mr. Allen and see what it showed. And so it was made clear to him in his discussions with the lawyers who were dealing with these cases that this was something that could be done.
The Court of Appeal observed that ARQ data was provided for the indictment period to the defence on the 26th of October 2012, shortly before trial was due, but that it was unclear what, if any, analysis was performed on it, and that there was no examination of that data for bugs, errors or defects, or indeed for evidence of theft.
Yes.
Did that accord with your own observations
Yes.
of the case papers here?
And as other cases where experts were instructed on behalf of the defence demonstrated that the difficulty of just giving a collection of data to the defence is that unless they had the necessary expert understanding of how Horizon worked, it was a very large job for them to analyse, to understand, even begin to understand how the system worked, let alone how it wasn't working. Whereas someone with knowledge of the system had that advantage. And a sub-postmaster I wouldn't include on what I read in that category to understand the technical aspects of the Horizon system.
Just going back to paragraph 532 of your report, as you mentioned, at Mr. Allen's case, that's on page 188. You tell us in this context that the failure to examine detailed data logs in order to investigate the specific issue was, to quote you, an unfortunate failure in the evidence. But that appeared to be a post office decision. Would that be right?
Yes. Yes, he meaning Mr. Jenkins, had indicated it could be done, but he wasn't asked to do it.
So Mr. Jenkins was offering to examine the data in addition to making a general statement about Horizon reliability.
Yes.
But the investigator and the prosecutor decided that the general statement was enough. Is that right?
Yes.
Would the course of action that Mr. Jenkins was offering to undertake have been more in line with the Post Office's duties as a prosecutor, both in terms of reasonable lines of inquiry and disclosure?
Yes.
Did you ascertain why it was that the Post Office investigator and or lawyer decided that it was sufficient to serve a general statement in place of Mr. Jenkins examining the underlying data?
There were various reasons given in various different cases. Insofar as Mr. Allen's case is concerned, I'm not sure that I did see a reason beyond the position which had already been stated, that it was for the defendant to identify what had gone wrong, and that they would then look at it rather than for them to investigate whether the system had been reliable or not. What was interesting, just while we're on this paragraph and in this case, is that another lawyer involved, Andrew Bulk, did appear here to be noting that the retrieval of the data from Fujitsu for these purposes would not cost the Post Office anything. And in other cases, cost was given as a reason for not doing things, but that what Mr. Bulk was saying here did tend to suggest that that wasn't right.
It wasn't operative, at least in this case.
Yes.
What view, if any, did you take of the fact that a witness was suggesting the possibility of a line of inquiry being pursued, identifying that examination of the underlying data, the logs, might be the appropriate course of action, but the investigator and the prosecutor were saying not to?
Well, it goes slightly further than that. This is the expert, as they perceived him to be, that they had gone to for his expert knowledge of the system, saying to them that this would be the appropriate way forward, and for the investigator and lawyer to say no to that which their expert was telling them would be the logical next thing to do, which in any event it should have been clear to them needed to be done.
Was that of concern?
Yes.
You, in your, that can come down, thank you. In that paragraph 532, and indeed elsewhere in your report, other paragraphs include 545 and 663. You are critical of the use of so-called generic statements concerning the reliability of Horizon being presented as expert evidence, and as a collateral point, placing an obligation on a defendant to specify particular issues with Horizon before any further investigation of those issues would take place.
Yes.
have I summarised
Yes.
that concern correctly? Did you form a view who was controlling this exercise, the extent to which specific inquiries were made? On the one hand, the post office, and on the other, Fujitsu, including Mr. Jenkins.
Insofar as I could see from what I had, there was this instance here of Mr. Jenkins volunteering that something further could be done in relation to the ARQ data. And in this instance, it was the investigator and the lawyer who said that that wasn't required. In other instances, it was lawyers such as Miss Panter who were saying generic statement will do. And so insofar as I could judge from what I could see, it was the post office side of things saying this is enough, rather than their expert or the company that he worked for telling them that it didn't need to be done.
I think you're nonetheless critical of the failure to make reference within the generic statement of material directly relevant to Horizon reliability that Mr. Jenkins was aware of at the time that he made the October 2012 generic statement.
Yes, because as an expert and bound by the rules in relation to what was required of expert evidence, he was required to identify that which was relevant to and potentially undermining of any opinion he expressed. And if he was expressing an opinion that the system worked properly and he was aware of material that might suggest to the contrary, then he had a duty to disclose that in his report, even if he hadn't been asked to.
You began that sentence with the words "as an expert."
Yes.
Can I ask you, please, an open question as to why you described Mr. Jenkins as an expert?
Firstly,
and what you mean by that?
Firstly, that was how he was treated, in the sense that when his statements were served in these various cases, when he was called in the case of Miss Misra, he was identified as an expert. An expert is someone who is expressing their opinion on a matter that is out with the knowledge of the jury. He was being called to express his opinion as to the operation of a computer system that had been produced by the company that he worked for, and about the operation of which the jury were unlikely to know anything at all.
In the light of that fact, did you identify, again this is generally, any instructions in any case to Mr. Jenkins, which instructions identify to him the duties of an expert witness?
No, none at all. And I should say, in relation to that I'm not in that sense relying on the Gareth Jenkins chronology document. I have been fortified since 4 o'clock on Friday when I received them by 2 lever arch files of correspondence between the post office and Gareth Jenkins, which shows a lot of contact between them, in not a single one of which were his duties as an expert hinted at.
Was that of concern to you?
Oh, yes.
What level was the concern that you felt?
Well, as I touched on in my volume 1A, the responsibility of someone instructing an expert as to what they have to tell their expert has evolved over time. Certainly now, and for a period of years before now, it's very clear from, for example, the CPS or the Health and Safety Executive that they recognise the importance of making clear to an expert what their duties are. The rules now make clear that they should do that. But the rules for an expert have been clear for quite some time. And the duty on a party to make sure that others involved, such as an expert they're instructing, comply with the rules, made it, in my view, obvious that they ought to have told someone who they're instructing as an expert what their duties were, particularly where they were aware, not least because he told them, that he hadn't done this kind of thing before.
We're going to come perhaps tomorrow to the detail of that. And you're referring, I think, to an email where he asks expressly for help.
Yes.
And says, I've not done this before.
Yes.
What should happen?
Yes.
What do I need to do?
Yes.
In this context, the present context I'm asking you, which is the preparation of the generic statement, do you agree that it was important for the Post Office prosecutors to tell Mr. Jenkins, remind him of his duties to the court, in particular in relation to the disclosure of any information that undermined the views that he was expressing when proposing that he should provide a generic statement concerning Horizon?
Yes.
And that didn't happen?
No.
Can we look, please, at poll 302 6567? And if we go, you'll see from the first page here that this is a case concerning Kim Wiley. Again, it's not one of the case studies, but it's the beginning of the trail which leads to the generic statement, I think. And it's we'll see that this is an advice by Harry Bowyer of Cartwright King.
Yes.
And it's after Second Sight have been announced as investigators. And if we just scroll through it, please. Paragraph 1, in my early advice, I advised we'd need to prove the integrity of Horizon as there was apocryphal evidence on the internet and elsewhere the system was leading to injustice. The position of the Post Office has up until now always been robust. When the system has been challenged in the criminal courts, the system has always been successfully defended. Second Sight's been announced. Whether this announcement was well considered or not is not an area I intend to address. But the bell cannot be unrung, and there will be consequences. And then if we scroll on, please. We have now given ammunition to those attempting to discredit the Horizon system. The argument will be there is no smoke without fire, and we would not have needed to audit a bomb-proof system. We can expect this to go viral, in that any competent defence solicitor advising in such a case as this will raise the integrity of the Horizon system and put us to proof as to its integrity. As all of our cases depend on the system to compute the alleged losses, this is likely to affect a considerable percentage of our cases. 4. The extra evidence which we will be obliged to gather will be as nothing in comparison to the potential disclosure problems we may face. Until Second Sight is concluded, we will be in limbo. It's essential it's completed as soon as possible, and we can live by its findings. Have to find out when this inquiry will report in order that we choose our strategy. If it's a matter of weeks, then cases can be put over until after its report. If we're talking months, the courts will not wear such delays. I assume we will contend that the system is foolproof, in which we should defend it aggressively. I understand the manufacturers have not been helpful up until now. My understanding is they will not provide expert evidence without large fees being sought. This will not do. If the integrity of the system is compromised, then the consequences will be catastrophic for all of us, including them. Financial consequences of convictions and confiscation orders being overturned and confidence in the Post Office bookkeeping being restored for future prosecutions will be astronomical. They should be made to understand that this is a firefighting situation. It's not just our house that will be burned down if the system were compromised. And then on to 6, please. We should attend to the following. Identify the contested cases, both criminal and civil, in which Horizon has been challenged. Identify areas of challenge and how we neutralised them. an expert report, or sorry, any expert's report should be retained for evaluation. An expert should be identified and instructed to prepare a generic statement which confirms the integrity of the system and why the attacks so far have been unfounded. This expert should be deployed in all cases where the Horizon system is challenged, and he should be prepared to be called to reply to defence experts on a case-by-case basis. Just stopping there and putting aside Mr. Bowyer's turns of phrase, did you identify anything problematic with the approach set out?
Well, the first point that occurs is that Mr. Bowyer is there identifying a need to consider earlier cases where issues with Horizon had arisen with a view to an expert now explaining why those earlier attacks had been unfounded, rather than there being any consideration here of whether the material generated by earlier cases where Horizon had come into attack was material that was capable of undermining the prosecution case, assisting that of another defendant, and therefore it being material that ought to have been disclosed to them. And the other point is that this, as it describes, is a generic statement to confirm the integrity of the system, rather than asking an expert to examine the integrity of the system in relation to any case that is going to be prosecuted. And so it's a bit like the press release that asserted that the system worked well, that Mr. Singh and others had been working on in 2012, rather than meeting the prosecution's obligations, both in relation to the reliability of their evidence or disclosure in relation to their case, of material that might undermine that, or at least to look whether it was reliable or not on a case-by-case basis, rather than through a generic statement.
So if we go to the last page of this document, if we just scroll on a bit, we'll see it's dated the 11th of July 2012, and that seems to be the origin of the idea of a generic statement.
Yes.
Prepared by an expert. Mr. Bowyer doesn't identify that the expert should come from Fujitsu.
No.
Or the identity of the expert.
No.
Can we go to poll 0014 1396? Can we see at the foot of the page, or sort of halfway down, Mr. Cash, a solicitor at Cartwright King, sending that advice over to John L. Singh from Mr. Bowyer, saying, I know it will be unpalatable, but for what it's worth, I share his view. Yes?
Yes.
And then further up the page, please. Mr. Singh distributes it. Hugh Cart, Wright King's lawyer, in the case of Wiley, has advice on evidence and also how to progress Horizon challenges in view of its content. Can this be forwarded to case officer and Dave Pardo at John L. Singh? So it's being distributed around the organisation.
Yes.
Do you view what had been advised, its adoption by Mr. Cash and its promulgation onto the post office, as consistent with the duty on solicitors who have the conduct of private prosecutions to discharge their duties to act as ministers of justice?
No, because it didn't identify, nor did anyone who received Mr. Bowe's advice identify that it was advising on a bandage rather than on an investigation of what the illness was or what the injury was. It was looking at how to protect the system rather than to assess the reliability of the fundamental evidence in the prosecution of sub-postmasters.
I should have said that Mr. Bowyer was in-house counsel rather than a solicitor.
Yep.
Did you regard the advice and its adoption and promulgation as consistent with the proper approach to disclosure in accordance with the CPIA and the Code of Practice issued thereunder?
No, it's effectively, rather than identifying a reasonable line of inquiry on the one hand and material capable of undermining the prosecution case, or that if it was in their possession might undermine the prosecution case, on the other, it was seeking a statement that would obviate the need for either. And so rather than checking whether the system was reliable, they would have a statement that they could just add to the bundle that would assert it was fine without checking. And they would have a statement that would close off inquiries on the part of defendants or disclosure requests from defendants in relation to the operation of the system, rather than identifying that there would be material that needed to be investigated as to whether the system was working properly.
Just before the break, can we look at poll 0014-1416, please? An email. Sorry, if we scroll down, please. And still further. Scroll down, please. So yes, and back to the top, please. Can we see this as an email? If you just scroll down a little bit, you'll see, I think it's from Mr. Bowyer. Harry, yes?
Yes.
And then to the top. This is, it's cut off, but it's dated the 6th of August. The advice we'd seen was July, if you remember.
Yes.
This appears to be what we want. Hopefully Helen will confirm the Horizon system has never been successfully challenged. I've yet to see any sign of experts briefed on behalf of the defence. When she's completed her exercise, she should prepare a summary of those cases where there's a proper attack on a system rather than a gripe that the system is at fault. Although she should record those cases so we can say that they've been kept under review, they will become more numerous as the bandwagon picks up speed. And then the expert will need to address the report to the following issues. And then 4 issues are identified. Can you see that?
Yes.
A description of the Horizon system, a declaration that it's yet to be attacked successfully, a summary of the basic attacks made on the system, concentrating on any expert reports served in past cases. If there are none, then state that no expert has yet been found by any defence team, civil or criminal, to attack the system. At the moment, there seems to be little more than griping by defendants. The system must be at fault without saying how. 4, plainly, like all accounting systems, there's room for human error, keying in the wrong amounts, etc. But the expert should be able to state that innocent human error is unlikely to produce the types of discrepancies of many thousands of pounds over many months. If we stop there, remember those 4 questions. and then come back after the break to see what happened to them and what they ended up being produced as a result of them. So can we break until 3:30, please?
Yes, of course.
Thank you. So can you see and hear us?
Yes, thank you.
Thank you. Mr. Atkinson, we had just looked at the 4 questions that Mr. Bowyer had prepared in his email of the 6th of August. Can we move on to September 2012 and look at poll 302-0489? And if we scroll to the second email down there, Mr. Singh says, Andy, that's Andrew Cash, thinking about choice of expert in this case, I've in the past instructed Gareth Jenkins of Fujitsu in the case of Misra, which, incidental, was the only challenge on Horizon. He provided expertise in dealing with defences bound less inquiry into the whole Horizon system. Perhaps we need to reconsider whether to instruct him, as he may be viewed too close to the system, but instruct somebody entirely independent, ? Your thoughts, please, and also whether you or Harry have anybody in mind. Thank you. And then further up the page, Mr. Bowyer says, I would have preferred somebody entirely independent, but this is such a specialist area that we would be hard pushed to get a report in the timescale we require. We might open our expert up to allegations of partiality, but his expertise will be unlikely to be challenged. And then there's some timing issues. In the light of that exchange, the Post Office internal lawyers on the one hand and the Cartwright-King lawyer on the other were seemingly aware, would you agree, of Mr. Jenkins not being functionally independent?
Yes.
Given the breathless tones in which Mr. Bowyer's memo had earlier been written as to this being a potential moment of crisis, do you agree that, given that significance that was being attached to the issue of the instruction of an expert and this recognition that Mr. Jenkins was not functionally independent, it was important that if Mr. Jenkins was instructed, that he should be made to understand that he was subject to a wide range of duties?
Yes.
As an expert witness?
Yes, and in particular, a requirement that he be independent.
What do you mean by that?
But it was essential that he understood that he was being asked to give his independent opinion about these things rather than to provide evidence that was mapped out for him or to give an opinion that he was being told to give, in effect.
Can we turn to poll 309-6978? We can see this as an email of the 1st of October 2012 to Mr. Singh. Sorry, from Mr. Singh to Mr. Jenkins. Also included in the distribution list is Penny Thomas of Fujitsu, Hugh Flemington at the Post Office, Martin Smith of Cartwright-King. Subject, Horizon Fujitsu report, very urgent. Welcome from your annual leave and your assistance advice in the past prosecution cases, and I understand you're assisting my colleagues at present. I need your urgent assist. Judge has this morning ordered the prosecution to have the following report ready to be served within 7 days. On advise, Post Office Limited have appointed one of their investigators, Helen Rose, as disclosure officer dealing with Horizon challenges. She's prepared a document spreadsheet detailing all such cases past and present, approximately 20 in total, although none thus far successfully argued in court. Post Office Limited have been advised to obtain an expert's report from Fujitsu UK, the Horizon system developers, confirming the system is robust. Just stopping there, is that the antithesis to the type of instruction that you just mentioned?
Yes.
Post Office Limited maintain the system is robust, but in the light of adverse publicity, from legal viewpoint, is that defence should be given opportunity to test the system, should they still wish to do so on consideration of our report. You will need to consider the disclosure officer's document, spreadsheet, see attachments, and need to address in your report the following issues. And then cut and pasted into this email is the Harry Bowyer 6th of August list of 4.
Yes.
Yes? To the extent that it's possible to understand what Mr. Singh was asking to be done by this email, do you agree that the email, on any view, omitted any instructions or guidance to Mr. Jenkins as to his duties as an expert?
Yes.
I think it also omitted reference to any specific prosecution, any specific defendant, any specific branch, nor did it refer to any Horizon data that might be analysed in order to reach conclusions.
Yes.
The email says that the report or Mr. Jenkins will need to address the following issues, and the 4 of them set out. But was this an appropriate means of instructing Mr. Jenkins?
As an email as a whole, it was far from an appropriate way to instruct an expert. It didn't set out what Mr. Jenkins' responsibilities and duties as an expert were, as we've already touched on. It didn't remind him of his duty of independence, that he owed his duty to the court and not to those who were instructing him. In terms of the 4 Bowyer points as cut and pasted into this, the first one, no difficulty with that, asking him to give a description of the system in layman's terms was not an issue. A declaration that it has yet to be attacked successfully, on the one hand, sounds as if it's telling him what he's got to say, which, given he's being instructed as an independent expert, would not be appropriate.
It's also false.
And that never helps.
Yeah.
And underlines the viewpoint that he's meant to be coming from, which had already been set out rather too clearly in the first large paragraph on the page. A summary of the basic attacks made on the system, and drawing a difference between griping and anything else, again was telling him what to say and how to approach it. And that the last point 4 is almost a script for him of what to say. And so what would have been appropriate would have been to identify a series of areas on which they were asking for his opinion as an independent expert, rather than telling him what his opinion was on a series of areas, and effectively telling him that he was being instructed to defend the system and to assert that it didn't have issues.
Are you able to say whether a person in receipt of such an instruction, if they knew of issues or defects that fell outside the four corners of the four issues that are mentioned, ought nonetheless to have set them out in any written document that was a reply to this email?
Yes, at the very least, you would have expected anyone who was aware of issues with the system to say, these are the issues with the system that I ought to address in this context. And so if by way of example, you were aware of a bug in the system that you had had meetings about in 2010, you ought to have been flagging that up in 2012.
Even if that wasn't a bug which constituted a successful attack by a defendant upon the system, or a bug that had been mentioned in an expert report served in a past civil or criminal case?
Well, at the very least, if you're being asked to put together a report that would go to court and which you would potentially have to answer to in court, you would be asking for guidance as to what, if anything, you needed to say about X that you were aware of that was an issue with the system that was beyond a typing error or griping.
What would you say to the suggestion that, to the extent that this was an instruction to a witness, it was to produce a report that addressed and only addressed the four specific questions as narrowly formulated by Mr. Bowyer?
I think I would say to that if you were putting your name to a declaration of truth in relation to this, at the very least you would be questioning whether a statement that just answered those 4 points and said nothing else when you knew there was more was incomplete or perhaps misleading.
Would you agree that in any event the four specific questions do not ask Mr. Jenkins to provide a general overview of software issues?
They're asking him to provide a generic statement about the system. Certainly my reading of it, I wouldn't see that as excluding software issues. But if it was unclear, then one could ask.
What about hardware issues? Same answer.
Same answer.
What would you say to the suggestion that the focus of this email requires Mr. Jenkins himself to focus on defence-led challenges in the course of previous litigation and nothing else?
Well, he was clearly being asked to deal with defence-led issues as in relation to question 3, but he was also being asked more generally to provide support for the Post Office view that the system was robust. That's clear from the paragraph at the top of the page. And he would also, by this point in 2012, have been aware of how wide-ranging defence questioning in relation to the operation of the system could be, because he had been questioned in the case of Miss Misra, and that had been wide-ranging questioning. So at the very least, he would have had questions in his mind as to what this needed to cover, I would have thought.
Taking a step back, however, for a person that was not, by training or profession, an expert witness, would you agree that as a letter or document of instruction, this was woefully inadequate.
Yes.
Mr. Jenkins, that can come down, thank you, duly produced a draft report responding to the 4 Bowyer questions. And this was circulated amongst others at Cartwright King on the 2nd of October. If we look, please, at poll 309 6997. If we scroll down, please. And keep scrolling, please. There, if we just scroll up to get the date. Harry Bowyer to Martin Smith and Andy Cash, so internal to Cartwright King at the moment. At first sight, these look like a good base upon which our reports can be based, as most are fishing expeditions. They will do in their current form. I've edited the last report because as it currently stands, it's an invitation for request for further disclosure. Can you put this past Mr. Jenkins? Can you draft generic Section 9 statements for the witness to produce the reports? This must set out his expertise to comment on the system, both the old and the new. We have to establish his right to speak as an expert. I'm in favour of the descriptive words being added to the diagram. Beyond that, keep it simple. The secret here will be to respond to the defence expert report rather than try to anticipate every rock to be thrown at us, unless they be obvious from the defence statement or interviews. If there is a specific challenge in a case, the statement and the report can be tweaked to cover the eventuality. My view is that most challenges to the Horizon system should now vanish away before trial. This seems to involve a discussion amongst the Cartwright King lawyers that defence cases that had raised Horizon issues were fishing expeditions.
Yes.
And it appears to proceed on the basis that the only point that needed to be established still further was Mr. Jenkins' qualification to give an expert report.
Yes.
It doesn't ensure or suggest we now need to ensure that Mr. Jenkins was properly instructed as an expert.
No, and doesn't refer to the need for him to provide a declaration of the kind envisaged by the rules in relation to his duties as an expert either.
Can we look, please, at poll 309 6999? And if we scroll down, please, and still further, Mr. Jenkins, Mr. Jenkins, dear John Eller, attached to the 2 existing reports I mentioned regarding Horizon and Horizon Online integrity, that they're a separate issue. Then further up, Mr. Singh, thank you for forwarding your report. As in previous cases, you kindly assisted in, your report needs to be put in a statement format. Perhaps you could look at your previous statement and let me have your qualifications, credentials, experiences, knowledge, expertise of the Horizon system. On receipt, I'll forward draft statement for your approval. So a request to put this in statement format.
Yes.
Can we look, please, at poll 309 7008? And then scroll down, please. Foot of the page. And keep going, please. If we just scroll up to catch the date, please. 4th of October. Mr. Jenkins to Mr. Singh. I've been in meetings, sorry for the delay. I've made some changes to tidy up formatting and add in some text below the diagrams, mainly posted from the reference documents. In the document you sent me, you were asking what the 2 documents referenced in section 3 were. They're the 2 brief documents on Horizon and Integrity and Horizon Online Integrity I sent you on Tuesday. I think it's clearer to keep these as separate standalone documents which can presumably be presented as part of the witness statement. You've also removed my explicit reference to the MISRA witness statement. Presumably this will also be available since that is where the main rebuttal of Professor McLachen's hypothesis is covered. Do you understand this to be Mr. Jenkins saying, although you're taking out my references in my witness statement to other documents, I presume that those other documents are going to be available
Yes.
in the prosecution
Yes.
in court?
Yes.
And then scroll up, please. Martin Smith to Mr. Singh. I've deleted the first paragraph of section 3. If the report served in its current form, defence will ask for copies of the documents. However, if Gareth as an expert feels that the documents should be provided, he will need to give them exhibit numbers. And scroll up. Gareth, I prefer to present the documents as exhibits. So can the wording of section 3 be changed accordingly? So it appears that Mr. Jenkins is saying, I want the documents that I previously prepared, the 2 reports, to be revealed.
Yes.
And as exhibits to my witness statement.
Yes.
Can we look, please, at FUJ 00153812? Please find draft statement. This is the 4th now at 11:43 for you to consider, amend and return. And then lastly, FUJ 00123982. The 5th, Miss Jennings, please find attached the section 9 witness statement. Not as simple as just cutting and pasting. In that final draft of the witness statement that was sent across, that can come down, thank you. The words, I understand that my role is to assist the court, had been added by either the Post Office or Cartwright King. Would you agree that those words, without more, were insufficient to satisfy the requirements arising on an expert report, either at common law or under the criminal procedure rules?
Yes.
The statement as served did not include a statement that Mr. Jenkins had complied with his duty to the court to provide independent assistance by way of objective and unbiased opinion in relation to matters within his expertise. Was that cured by the inclusion of the words, I understand that my role is to assist the court?
No.
Can we look, please, at poll 309-7061? And scroll down, please. And again. And again. Thank you. Just a bit further. And a little bit further. This is a generic email, it seems, that goes out from Sharon Jennings to a series of witnesses in the Patel case, including Mr. Jenkins. Case is up for trial at Peterborough Crown Court, but has been put back until the 14th of January and listed for a 7-day trial. And then scroll up, please. Mr. Jenkins replies, "Sorry, but I'm not aware of this case or what might be required of me. I'm not aware of any outstanding cases which I might be involved in." Further up the page. Miss Jennings replies, "This is the one that you supplied the expert report and witness statement for the week before last." I think that's a reference to the generic witness statement. "Apologies for not explaining that properly in the previous email. It was a blanket email for all witnesses. It's unclear at this stage who will be required as witnesses and which evidence will be accepted without the need for attendance." And then the rest of it is concerned with Andy, and then scroll up the page, please. And a little further. "Thank you for the clarification. I had not understood that that related to a specific case." I think that's the generic witness statement. "I thought that was a general statement. If I'm required to go to court for that, I think I need to have some more background on the specific case and exactly what is being alleged. I appreciate that's not covered by my statement, but if I need to be an expert witness, I need to understand what is happening. Please note, if I'm required to do anything further on this, some commercial arrangements will need to be made to cover my time and costs, since I'm not covered by normal security service, the normal security service that the Post Office pays for. Perhaps you can sort out the details, etc." And then up the page, please. A little bit further, we can see that Ms. Jennings replies to Mr. Jenkins amongst a large collection of other people, but most specifically addresses her reply to Post Office Security, the generic email address. There appears to have been some sort of confusion regarding the trail of emails below. Gareth was asked to supply an expert report on Horizon Integrity by the legal team, and I was asked to input this into a Section 9 statement in order to produce it in court. Gareth wasn't aware that this related to a specific case and was also not aware that he would be required in court. I've spoken to Gareth, he's happy to attend, but as explained below, it's over and above the usual business as usual arrangements that we have with Fujitsu. Some extra arrangements are required in order to cover extra cost and time. Putting aside for the moment the parts of the emails that concern the extent of the BAU arrangements and the provision of extra costs and time, do you agree that this is a concerning exchange of emails involving Mr. Jenkins?
In the sense of his apparently not having understood what he was providing the generic statement for, yes, it is.
He, would you agree, appears to be under a state of some confusion as to the role that he is performing.
Yes.
He says, "I thought this was a general statement. If I'm going to come back to court for a specific case, I need more background on the specific case and what is being alleged in that case."
Yes.
In your oral evidence to the inquiry back on the 6th of October, you stated that the cost of obtaining material was not a relevant consideration in deciding whether to seek material from a third party.
In general terms, that's right, yes.
You identify in various places across your Volume 2 report instances where cost appears to have been a factor in decision making.
Yes.
Was this exchange amongst those areas of concern?
I don't think I had seen, in fact, looking at how they're described, I hadn't seen this exchange, and so no, it wasn't.
That can come down, thank you. During your oral evidence for the inquiry, again back on the 6th of October, you stated that when making decisions on disclosure, the prosecutor should not restrictively analyse the case of a defendant, not least because the defence might not be able to identify something that they don't know anything about.
No, and the Attorney General's guidelines, by way of example, make that clear.
You, I think, have seen a range of correspondence amongst post office lawyers and between post office lawyers and investigators, in which the lawyers adopted the view that it was for the defence to identify what the problem was with Horizon.
Yes.
Did you form a view as to the appropriateness of that approach?
Yes, I thought it wasn't appropriate at all.
Can we look, please, at poll 305 9404? If we go down the page, please. And scroll down, please. And again. And again, please. And again. So we get, if we just scroll up a little bit, an email of the 16th of November 2012 from Rachel Panter. Yes?
Yes.
And if we scroll down, please. She says that most, if not all, cases raising the Horizon system as an issue have been unable or not willing to particularise what specific issues they may have had with the system and how that shapes the nature of the defence.
Yes.
That's similar language to the email that we saw earlier, I think, from Mr. Bowyer.
Yes.
Is that consistent or not consistent with the proper approach of a prosecutor to the issue that you're presently addressing, namely whether it's for the defendant to, in these Horizon cases, identify an issue before with Horizon before the prosecutor investigates it?
It's putting the onus on the defence to identify the specific respect in relation to which the Horizon system was not reliable, rather than recognising the obligation on the prosecution to satisfy itself and then others as to the reliability of the system that underpinned its prosecution.
And if we scroll up, please. Thank you. Mr. Jenkins says, can't you use the report I've already sent you? There's no mention of the case. That's Kaya Mishak on the report. You should really be addressing such requests through Post Office Limited rather than directly to myself. There's no commercial cover in place for me to spend time on such activities. And then up, please. James Davison, a delivery executive at Fujitsu, says, I'm concerned at the engagement approach being taken here. We're fully on board to support, but all approaches must come through Post Office by the correct change process. And then up. And keep going, please. And again. And then a reply to both James Davidson and Gareth Jenkins. Apologies if I've approached this in an unconventional way. In response to your email, Gareth, second paragraph, I do intend to use the report you've already provided. And then this, it doesn't matter that you've not mentioned a specific case in your report, as there has not been any specific criticisms raised by the defendants provided in my list of cases. It would be a different scenario if there had been specific criticisms made, as your report would have to respond to that particular issue. Does that approach evidence the vice that you were mentioning a moment ago?
Yes, because in any one case, a postmaster, while being interviewed, may have identified that they were experiencing problems. They may even have said something about the circumstances in which they were identifying those problems, or the periods during which they were experiencing those problems. And there was then a responsibility on the investigation and the prosecution to test that, to see if there was something that explained how that might have been, either to rebut it or to identify material that was capable of supporting it. That is a specific exercise for a specific case based on specific facts and based more particularly on specific data. It is not something that doesn't matter because the sub-postmaster wasn't able to give technical chapter and verse as to exactly what had gone on.
Would you consider this to be a further example of the Post Office restricting its evidence and its disclosure obligations by reference to the way in which the defence case was put?
Yes.
Thank you, that can come down.
It was not identifying a reasonable line of inquiry, and it was not grappling with their disclosure obligations.
Thank you. Can we turn to topic 6, please, which is a wider issue of third-party disclosure. It's paragraph 666 of your second report. Which is on page 238. Page 238. You say there was no real discussion that I have seen beyond this discussion as to cost, and this discussion as to cost is referring back to some previous paragraphs, in particular concerning the Seema Misra case, where the cost of obtaining disclosure was a topic of discussion.
Yes.
There was no real discussion that I've seen beyond that discussion as to cost of the relationship between the Post Office and Fujitsu in relation to the obtaining and disclosure of material held by Fujitsu that was potentially relevant to the Post Office's prosecutions. Are you identifying here that you would have expected to see some written exchanges, some communications between the prosecutor and this third-party provider of material about how the third party is going to provide material?
Two stages. That is the second stage. The first stage is I would expect to see discussion between investigator and prosecutor as recognising the need to material from the third-party Fujitsu because it was potentially relevant either as evidence or as disclosure as to the reliability of the system that was operated by Fujitsu.
Did you identify any examples or occasions on which the Post Office made clear to Fujitsu the nature and scope of the Post Office's disclosure obligations?
No.
As to the Post Office's obligations to obtain material from third parties such as Fujitsu?
No.
As to the categories of material that Fujitsu held and which were potentially relevant for at least consideration for disclosure in a prosecution?
No, and as part of that, under the Attorney General's guidelines, there was a requirement on the prosecutor an investigation to notify a third party that might have material that it might need to seek to ask it to retain the material at the very least.
Well, that's where I was going next. Given that requirement of notification under the AG's guidelines, did you see any communications that at least put Fujitsu on notice as to its retention policies, given that the data that it was producing may be needed in a prosecution?
No.
Thank you. Can we turn to topic 7, please? Disclosure and unused material. Way back in paragraph 17 of your report, which is on page 12, you say in procedural terms there was in particular failures of disclosure in relation to Horizon data. This included the failure to disclose the underlying material that the failure to disclose the underlying material to that relied on, including ARQ data, either at all or to the extent necessary. The attitude appears to have informed disclosure was the belief that the defence should identify with clear focus what the problems were. I'm sorry, I'm reading from 18.
Yes.
That was a flawed approach. And then going back to 17, in procedural terms, the disclosure officer, who was also the investigator, usually did prepare the schedules of unused material. These were often inadequate in terms of their content and description. There's little evidence they were reviewed as required by the prosecutor. Decisions as to disclosure from the schedules were flawed or overly restricted. That position in some cases improved by action from trial counsel. The full code test under the Code for Crown Prosecutors required, is this right, a prosecutor to consider whether reasonable lines of inquiry had been pursued?
Yes, the code in that respect evolved over time, and that requirement became clearer with each iteration.
It required the prosecutor to consider whether any further evidence or material was likely to affect the application of the full code test, whether in favour or against the prosecution.
Yes.
And the evidential stage, and I think this applied at all times, required a consideration of the defence case and therefore necessarily involved consideration of material that might undermine a prosecution.
Yes.
Would you agree that in the light of those requirements of the code, it's difficult to see how a prosecutor could apply the full code test if they haven't seen a schedule of unused material at the point at which they're deciding on charge?
Ordinarily, you would expect that they would. The alternative would be for them to be provided with all the unused material instead of a schedule of it, but they'd have to have one or the other.
And would you, in that alternative way, agree that that would necessarily involve some rigorous means of ensuring that an appropriate search had been carried out by the investigator with appropriate diligence, and that the material which might undermine the prosecution case or assist the defence had itself been provided to the prosecutor?
You would expect them to check what they were given, and if it didn't fulfil the requirements that you've just set out, then they should be going back to the investigator requiring it rather than making a decision without it.
So the point I'm exploring with you is that at the point of deciding on charge, advising on charge, and we looked at a run of advices on charge earlier, at that point, should the prosecutor either have material equivalent to unused material or a schedule of unused material?
Yes, or should be asking for it if it's not being provided.
And shouldn't advise without it?
Certainly shouldn't, advise as to charge without it, no.
Can we look, please, at poll 305-2884? This is the charging memorandum of, in relation to the prosecution of Tahir Mahmud. It's dated the 27th of May 2005. And we go to the second page again. Let's scroll down. And the third page. Juliet McFarlane. And if we scroll up, please. Paragraph 1 says there's sufficient evidence. Yes?
Yes.
But then if we scroll down, if we see under the numbered paragraphs, 2 paragraphs on, beginning, you will be aware.
Yes.
You'll be aware of the provisions of the CPIA concerning disclosure. Paragraph 410 of the Security Community Codes of Practice and paragraphs 5.1 to 3 of the codes. Please let me have the necessary information on forms C, D, and E. The schedules must be signed. That refers, amongst other things, to the schedule of unused material non-sensitive, schedule of unused material sensitive, and the disclosure officer's report, those 3 form references.
Yes.
So it appears, in this case, that advice was being given as to sufficiency of evidence before unused material schedules had been provided to the reviewing lawyer.
Yes.
We've heard evidence from Mr. Utting. That was on the 17th of November this year at page 104 of the transcript. And from Miss Brander, Ruth Brander, on the 29th of November 2023 at pages 25 and 26 and 158 to 160, that unused material schedules were only ever prepared after committal and then only in the event that a not guilty plea was indicated. Is that approach consistent or inconsistent with what the law required?
It would be...
I should ask that question in a better way.
Yes.
In terms of provision of the schedules of unused material, is it right that the law only required those to be provided to a defendant post-committal?
To a defendant, yes.
In relation to the prosecution approach to whether there was a sufficiency of evidence, was that in accordance with or a departure from good practice?
Sorry, for them to be provided to the prosecutor?
Yes.
good practice would require that they were provided to the prosecutor, either the schedules or the material that would otherwise be on the schedule before a charging decision was made, rather than after that point in time.
I mean, if we look, for example, at the Josephine Hamilton case, I'm going to pick some other examples here. Poll 306 4235. We can see a disclosure officer's report. If we scroll down, I think this should be dated the 3rd of January 2007. Miss Hamilton's first appearance in the Magistrates' Court was the 6th of December 2006. And so it post-dates it by a month or so. So acceptable from a service upon defence perspective, but not good practice in relation to prosecutor. Is that right?
That's right, yes.
You helped us in your first report, that can come down, thank you, about a common law duty of disclosure, which arose prior to the initial duty of first stage disclosure under Section 3 of the CPIA. Do you remember a cross-reference to the case of Lee?
Yes.
Namely, a prosecutor needing to be alive to the need to make advanced disclosure of material of which he is aware, which might enable a defendant to make a pre-committal application, including a pre-committal application to dismiss. Was there any evidence in the cases that you saw that that duty was recognised?
No.
Was there any evidence in the cases that you saw that any common law pre-committal disclosure was given?
It wasn't very clear to me what was provided pre-committal at all in terms of what was provided at the first appearance, if that was a separate hearing, for example. No, I can't say what was given.
Is that a cross-reference back to a point you made very early on, that the material was relatively lacking in terms of what was created and served at the point of the initiation of process against the defendant?
Yes, so there was no material in any of these cases that I saw as to what was provided to the Magistrates' Court when the application was made for a summons, or what was provided to the defence pre the service of a committal bundle.
In terms of what the schedules in fact looked like when they were served, you tell us in paragraph 654 of your report on page 233. Page 233 of your report. Page 233. And paragraph 654. You say such schedules, for example, of non-sensitive unused material equivalent to an MG6C. That's a cross-reference to the Manual of Guidance series of forms. Yes. Used by the police service. Yes. And the Crown Prosecution Service.
Yes.
Were drawn up by the disclosure officer who, where named, was also the investigator. Such schedules were quite short and mainly included correspondence and documentation relating to the interview process. They lacked any reference to the underlying raw accounts data. To the extent this was not included in the served evidence, usually no reference to any previous complaints or discussions by the defendants with managers or helplines. This applied in cases where the defendant complained about the system or referred to such complaints and discussions as much as where they had not. So schedules were short.
Yes.
The preponderance of material, is this right, was about the interview process?
And correspondence at the time of the interview. Yes.
Overall, were the contents of the schedules as you would have expected?
That which was there, generally speaking, was correctly there, but there was an awful lot that wasn't there that should have been.
Was it a short distance or a very long way from what you expected?
Well, the difficulty in answering that is that it may well have been that things were not listed as material in the prosecution's possession that was not being relied on in evidence, so unused material that was not being listed there because it didn't exist, because they hadn't followed through the reasonable lines of inquiry that would have led to them having it. And so the two really are connected. So, for example, they would not include reference to ARQ data on the unused schedule because they hadn't asked for the ARQ data, and so they didn't have the ARQ data as unused material. But clearly, they should have followed that reasonable line of inquiry. Therefore, they should have had the data. Therefore, they should have included it on the unused schedule, and therefore the unused schedule was deficient. But it was a continuum of missed opportunity in that respect.
Thank you. In terms of review by a prosecuting lawyer, you address this further down the page in your paragraph 656. And you say, in the main, the unused schedules I have seen did not show on their face any evidence of a review by the prosecutor having occurred. This makes it difficult to be satisfied this important task was undertaken. You accept that this may, at least in some cases, have been an omission of annotation rather than of review. Are you saying there that this may be a case where reviewing lawyers had reviewed the schedules but hadn't marked them in a way to show that they had done so, i.e. countersigning them?
So it varies. There were some cases, in fairness, where there were annotations on the face of the schedule that showed that the lawyer had reviewed it and come to a view as to disclosure, which is what was required under the CPIA code, under the Attorney General's guidelines. There were other cases where there was evidence that the lawyer had looked at the schedule through other documentation, be it in the case of Mr. Mahmud, there was a memorandum from the lawyer asking the investigator what was disclosable from the schedule, which was an interesting approach, but at least showed that they'd registered they had the schedule. And there were cases where there was an accompanying letter that I saw that was sent to the defence with the schedule that told the defence that there was nothing on the schedule that was disclosable, which I took to be an indication that the lawyer had reviewed it and come to that conclusion. But in the majority of cases, there was none of that and nothing on the face of the schedule to show one way or the other whether they had reviewed it or not. But clearly they should have done.
You say over the page in paragraph 657 that the stance, that's the stance in the Josephine Hamilton case, that nothing was disclosable, appears to have been adopted in a number of other cases, whether on the schedule itself or more often accompanying correspondence indicated that everything listed in the schedule was C&D, clearly not disclosable. And you say, in my view, such an assessment was often in error. Why was that so?
I identify where I have a schedule and that conclusion in the individual cases. There were instances of material that was within an all-embracing, clearly not disclosable decision that, on seen to me, on my, I accept, limited reading of the material, clearly was disclosable because it was, on the face of it, material that undermined the prosecution case or assisted the defence case. It included things that now are recognised within the present version of the Attorney General's guidelines are standard disclosure, for example, interview tapes.
And did this position change across the relevant period, i.e. did the 2010 policy change have any effect on the practice adopted of saying everything is not disclosable?
Not that I could see, no.
So thank you. I'm about to move to topic 8, cross-disclosure of Horizon issues. I wonder whether that might be an appropriate moment to break for the day.
Certainly. All right. Thank you very much for answering all those questions, Mr. Atkinson. I'll see you in the morning. 10 o'clock tomorrow?
Yes, please, sir. Thank you very much.
Fine.
Thank you.